Good morning, everybody. Thank you for inviting me, and thank you to BAFT. I'm thrilled to have to follow Lisa Chin. Lisa, that was a fantastic presentation. So always a challenge to follow you in any of these. But today we're going to talk about counter standby letters of credit and guarantees. And with me I've been fortunate enough to partner with Vivek Singh from BNP on this session. Vivek and I are going to approach it in two different sections. The first section we're going to talk about the counter standbys. We're going to talk about why we need them and just considerations and other issues with regard to issuing what I like to call the first leg of the transaction. And having Vivek here and giving it a, since we have predominantly a US based audience, having Vivek is going to be great because he's going to focus in on the URDG aspects. And I think URDG does a really good job at the counter standbys. And so Vivek will talk about in the second half about URDG, about local law, some of the issues and challenges that we face, that he faces when he's receiving, the counter standbys to issue local guarantees and other concerns. Again, looking at it from the offshore and from the local issuer perspective. I don't know, Vivek, if you want to add something to that before we get started.
No, that's very, very, very concisely put, Frank. But hi. Well, I never said that before. So again, my pleasure also to connect with you, Frank, and everyone on the call for this very interesting topic. And exactly as I said, you very accurately put it. The reason I will be on the call. I'll take the second part of it, but with the interest of time, I'll let you proceed with the first couple of slides, Frank.
Thank you, Vivek. So I just have a really pressing question. Are you still on holiday?
Yes, I am.
What a dedicated banker.
Yes, I am in the middle of nowhere. Trust me.
No kidding.
Literally.
Wow. Well, welcome and thank you for doing this while you're on holiday. Next slide, please. Okay. So, I'm finding that counter standby and guarantee arrangements for our clients are becoming much more important to our clients. What's happening is, customers are expanding their markets. And so, customers historically would be, businesses would be doing business in their local country. But, as those markets change and as the opportunities for globalizing the products, their services, become increasingly available, customers have needs for, bid bonds, performance bonds, warranty bonds, customs bonds to be issued locally by local banks. And so the challenge comes in for our customers is they have banking arrangements with their customer in country. And, they don't have banking arrangements offshore or wherever they need the letters of credit issued. This isn't an issue for simply offshore issuances. We do run into this domestically as well. So how do we get there from here? So customer approaches you and says, hey guys, we need to facilitate the issuance of this local instrument. And so, that's where the banks come in and leverage their correspondent network and leverage the counter standby guarantee arrangement in order to deliver for their client. Okay, next slide, please. Okay, so when you're looking at a counter standby and guarantee arrangement, the key for me is speaking with the client and setting expectations. Clients need to provide us with the information that they have on the request. Specifically, if there's a specific bank that's been named that they need issued, what country is it going to? Do they have an LC format? When does the guarantee need to be in place? a lot of that information so that the bank can coordinate, identify the appropriate partner bank that they're going to use within the transaction, and leverage their experience, their knowledge, their understanding of what needs to be done in order to get that local guarantee issued. There are times when you're going to need to set that expectation that the client needs the local guarantee issued in a day or two. And that may not be logistically possible, especially given where they're doing business. We also need to look at the beneficiaries of these and understand whether what type of bank they're looking for. I know in Canada, for example, I've run into situations where the beneficiary needs a tier one bank, essentially one of the main indigenous banks in Canada, and not the JP Morgan office, which is a branch of a foreign entity, which is considered, I think, a tier 2 or tier 3. So they've got them all laid out. So those are the types of things you need to consider. Also, language. Very often, we're going to have to facilitate the issuance of a guarantee in a language other than English. And often you're going to, well, in certain situations, you'll find that you may need not only one counter, you may need two counters. I know historically, when I have a client that's that needs a bid bond issued in Algeria, one of the challenges we run into is we're working with banks in Algeria. They require local guarantees to be issued. As a US bank, I'm not issuing guarantees, I'm issuing standbys. So what I end up doing is issuing a counter to a French bank that has the ability to issue in the French language and is willing to issue the local guarantee. And then that French bank issues to the Algerian bank, who then issues the local bond. And so coordinating all of that and setting expectations with your client as to how long that's going to take is key. Also, working out that language with your correspondent bank prior to issuance is also key. One of the things that we've run into situations where we have issued the local the counter standby, and the local guarantee hasn't been issued for weeks or even more than a month, because that coordination piece had not been completed prior to issuing. The client wanted the guarantee, the counter standby issued right away. Unfortunately, they're paying for exposure that is not really doing them any good, because they can't get that counter standby set in place. So it's real important. That coordination piece is critical. Knowing the rules is absolutely critical. What you've got here and where it's interesting is, as a US bank, I'm issuing an ISP based counter standby to an offshore office that is going to issue a guarantee subject to local law, subject to URDG. So we need to keep that in mind when issuing our counter standby, and there may be some local law considerations that we need to share with the client and keep in mind, as we're doing this issuance. One of the other things, as you're talking to your customers, and again, focusing in on, we've got two or more separate instruments. There's going to be bank charges that they need to be aware of. I recently had a situation where the bank that we had engaged for a performance bond has recently been increasing their pricing. And not a whole lot you can do to control that, unfortunately, but the client not terribly excited about that. One of the other things that I missed earlier, but a client also needs to keep in mind when there is a counter standby arrangement that is being made, that local bank is extending credit. So everything that I would do as an issuing bank arranging for credit, making sure KYC is in place, all of that good stuff also needs to be done by that foreign bank. So it isn't something that can be turned around quickly. So it's a concern. The other thing is keeping in mind certain jurisdictions where you're not able to facilitate the issuance, and I'm seeing this a little bit more, is more and more countries now are pushing back on issuing a letter of credit that contains issuing an open-ended letter of credit that contains a that's backed by a counter standby that is that contains an auto extend. There's certain countries, Switzerland, we've run into problems. India has had issues with that. And so, that poses other challenges where, and France also is another one where we've had that situation. And so we've had to get creative in how we accommodate that, or, so there are times when we just need to tell the client that, we're not able to support the request and suggest that they may want to consider using another bank or certain alternatives like, cash collateral. I know in Germany, there is, for at least for leases, escrow arrangements, surety bonds, and LC confirmations are some of the things that will, help as an alternative to, the local bond. Very often, unfortunately, when they're working with the government entity is very, focused in on getting the bond. And so it really kind of pushes the boundaries of creativity. And I found that that is where we really get, excuse me, creative with some of the things that we work with our correspondents, our good correspondents who have helped us out countless times on these types of arrangements. And so it's great to, have that that connectivity. I'll tell you, I've been doing this for years, and the one beauty of as we move forward is communication is huge and is super helpful, and everybody's available via email. You may have some time business day issues, but it just seems as if we have that communication and we're able to facilitate a network with our correspondents in order to serve our clients. And so with that, I'm going to transition over to Vivek. Next slide, please. And Vivek will take us from there.
Thanks, Frank. Very precisely put. I think I was just thinking about it when you were talking about the challenges and laying down the foundation. It's funny, we were asked to tackle the various challenges of a counter standby usage, and one of our biggest challenge today as we speak is to wrap this up in 30 minutes. Now it's I think what, 25 odd minutes. I'll try my best. I'll just jump straight into it, cut the chase. For me, the principal difficulty of a counter guarantee or a counter standby practice is the possibility of misalignments between the counter undertaking and the local undertaking. We know that. However, I'm not saying that these misalignments, are making these practices any less efficient. On the contrary, a counter guarantee or a counter standby scheme remains, I think, one of the most efficient, popular, and the cost-effective way to secure your client's contractual obligations in a foreign land. Like you mentioned, Frank, what happens if the alternatives that you just mentioned do not work, or the client is simply not in a position to issue local credit lines? He is going to come knocking on your door saying, hey, look, I won this precious contract. It's going to run for, I don't know, 10, 15 years, maybe more. It's with a European counterpart, it's public. And state-owned enterprise or an Algerian guy, I don't know. And it requires me to put into place a security that is going to, of course, the expectation is for that security to remain valid until the time the obligations under the contract are fulfilled or validly discharged. At that point in time, what are you going to tell your client, my regulations in the country that I'm operating do not support open-end commitments. That's pretty hard to sell. You will have to find a workaround, like you said, find some creative mechanisms. And one of those result of those creative mechanisms is a tenor mismatch. The curious case of a tenor mismatch that I'm going to be talking about here. But before I do that, I think it's important to remember for all parties who are acting as counter issuers that if not for the request for issuance, the local guarantor would not be issuing their commitment. They would be busy doing their business. There will be no obligations whatsoever. So what I'm trying to put across here, the message is for the local guarantor, you, the counter issuer, acts as its bank client, giving instructions for the issuance. And therefore, depending on the geographies involved, on the rules and the jurisdictions, these two commitments or more will be subject to. The local guarantor will expect you to provide sufficient cover for it to move forward with its local issuance. And more importantly, it will expect you to keep it indemnified until it gets fully discharged of its obligation under its own commitment that it issued based on your request. And now the most important part is where this obligation of the counter guarantor comes into place to keep the local bank indemnified. I don't think it's anything to do with the or only dictated by the terms of the counter commitment. I think, and dare I say that this obligation to keep the local bank indemnified comes from a separate, hidden, parallel dependent promise that stems out of the fact that the counter guarantor or the counter issuer has requested you to issue. Remember, if not for you, they would be busy doing their own. They would be happy doing their business, going about their business, and not enter into this open-end commitment or longer-term commitments. We'll tackle those in the next few slides, especially how the rules, the two different rules, ISP 98 and URDG, tackle this interesting relationship. But okay, I'll come back to the tenor mismatch. There are times when you will, as a counter issuer, based on the regulation, as I said, in the state, at least how the regulations are interpreted, banks are not in a position to issue open-end commitments. But yet you have a contract that runs for a relatively longer period of time. Then you have credit agreements. Also, correct me if I'm wrong, Frank, I think most of the banks in the US draft their credit agreement with the client with this particular clause in that, which does not support a straight term exceeding anything beyond 2 or maximum 5 years. That's the maximum you can go based on, or maximum you can assume in terms of the client's credit risk. But then here on one side, you have the client, you have the regulations restricting you to to not issue open-end commitments. You have the credit agreement restricting you to issue nothing more than 2-3 years. Yet you have a client request who asks you to support him for 5, 10, 7, I don't know, 15 years or open-end, just until you get a discharge. What are you going to do? This is exactly what causes a tenor mismatch, where an American banker who is restricted both under the regulation and by the terms of its facility agreement with the client issues a counter standby with a fixed term, say 2 years. That's what the credit agreement allows, in favor of a local bank to support its local commitment, which goes on for a longer tenor, say 7 years or even open end. Of course, it will never be easy to convince a local bank to accept a shorter counter, a counter that runs shorter than the local's commitment, because it exposes the local bank to certain amount of risk, both operational and accounting. And that explains why the latter would ask you for appropriate cover, especially if the commitment is subject to, your counter is subject to ISP 98. And I will come back to that in a moment. Before that, I think there's a specific particular situation where we can talk about that a counter without having an automatic extension clause, so a fixed term, is supporting a local commitment which runs for a longer term or for an open end. Most of the time, you will see that the local bank will ask the counter to include an automatic extension clause. But sometime in exceptional situations, the local bank may accept a counter without an automatic extension clause, but with a fixed tenor, and that is shorter. When that happens, when the local commitment has something what the industry calls pay and walk clause. Very, very interesting and a market practice in the Australian region, I can say that. As the name suggests, as we know, it allows the issuer of the commitment, the local commitment, to pay at any time at its sole discretion the then available amount of under its local commitment, irrespective of it having received a complying demand from the beneficiary. Now, this is clearly not in line with the founding principles of a demand guarantee. We all know a demand guarantee is payable only against receipt, physical receipt or electronic receipt now in the terms of digitalization, I can say, receipt of a complying written demand of payment. If there is no complying demand for payment, the demand guarantee will not be paid. Yet you have a pay and walk clause that allows the issuer to just pull the plug out and walk away. No questions asked, no liabilities incurred. In this particular case, it is possible that the local bank may accept a shorter term counter because it may be looking at this in its local commitment and thinking that in a worst case scenario, if I'm not comfortable with the risk, I'm going to just invoke the pay and walk out. But this particular clause or this particular scheme has serious consequences, and therefore it must be discussed with the client as to what exactly will be the implications of having the local commitment with a pay and walk clause. There are chances that the local guarantor at any point in time decide to just pay off the commitment without receiving a compliant demand under the guarantee, let alone a contractual default of the applicant. So it's again important to have a conversation with the client on this part. Coming back to the misalignments in the tenor mismatch topic, still it's the famous topic of automatic extension clauses. There also, I can tell you from a recipient perspective, even when you propose to support a local open-end instrument with a counter with an automatic annual extensions, you will see that maybe you will not see because we are completely familiar with standby practices and how they work. So we are fully familiar as to what happens or what is supposed to happen when the counter issues a notice on non-extension. The local guarantor is supposedly required to claim, provided, of course, the counter provides this kind of provision. In most cases, the counter should provide a position or an entitlement for the local guarantor to claim if there is a notice of non-extension. But it still exposes the local issuer who has exclusive knowledge on demand guarantees only and nothing or little knowledge on standby. It can still expose them to operational risk, and it can be as silly or as unprofessional as simply missing out on the notice or non-extensions and not claiming and let the counter just simply expire. You will be having stuck with an open-end commitment with no cover at all. Forget a cash collateral. That's a different story altogether. How to deal with cash collateral, and I think I can talk about that in the next few minutes as to automatic extension clause or counter commitments with automatic extension clause do raise some genuine questions that remain unanswered, in my opinion, and will always be tackled by the relative applicable law and regulation of the place of the local guarantor. For instance, what happens when an open-end counter is collateralized due to a drawing under the counter? What and where does this cash exactly go until the local commitment is either claimed or discharged? How do you book it? The most rational conclusion, of course, will be to book it under an internal account of the local guarantor against the name of the counter. But then one argues as to if the counter has paid out its commitment in full, why will you continue to incur? Why will you continue to book the commitment in the counter guarantor's name? What additional responsibility does it have against or vis-a-vis the local guarantor when it has already paid out? Of course, the reason is for having this kind of booking is the corresponding commissions and charges that will continue to incur as long as the local commitment is alive and valid. And it is this part of the negotiation whenever working with this kind of scheme that takes the most of the time. In my opinion, as you said, logistics always is a pain. And when you are stuck with tenor mismatch, it's never easy to come into a final conclusion. Even if you look at automatic extension clauses, they will, one on the outside or on a greater picture, it will show you, or it will appear that automatic extension clauses do support the tender mismatch situation, and they will mitigate the operational risk to a great extent. But as I said, there are still gaps that will always need special consideration and on a case-by-case basis, namely the topic of fees and charges. For instance, I was just reading this very interesting article where it was mentioning a particular case where the counter issuer pays out following a notice on extension, and therefore it's out of its commitment. The commitment is expired supposedly, but there is a dispute under the local commitment between the local guarantor and the beneficiary, and the guarantor incurs litigation fees. The question was, can it still, after having sought out the litigation dispute, can it still, the local guarantor, fall back on the counter issue for the reimbursement of charges? If so, based on what relationship? Exactly on what relationship? Is it according to the terms of the commitment, counter commitment, or the dependent surety promise that I earlier spoke about? Maybe a food for thought. Let's leave it to that. Moving on. So the next slide is the currency mismatch, which is probably caused due to the counter guarantors or counter issuers' unwillingness or rather inability to pay in the currency of the local commitment. While instruments issued in commonly traded currencies will not face much of an issue, we know that, but it is the uncommon currencies that needs to be dealt here because of the potential and the frequency of the fluctuations involved. And trust me, Frank, we know that not every local bank outside of the States or Europe is excited to receive payment in US dollars or euros. They're always regulatory. It might hurt our ego, that's fine, but there are always regulatory constraints with the handling of foreign reserves. And won't you agree with that, Frank?
Absolutely, Vivek. And I'll just add another layer to it. And it's something that you mentioned earlier. Especially when it comes to these credit agreements that clients run into. I, time and again, have found situations where a credit agreement was entered into with the client. The client really never discussed where they're going to be doing business. So there wasn't a provision in there to issue letters of credit other than USD and maybe a couple of other currencies. I find a lot of attorneys, when they're building these credit agreements, may take an agreement off the shelf and put in kind of a standard provision. So unfortunately, in that credit agreement, they're not able to issue in pounds or euro or any other currency, which then what they try to do then is through the letter of credit, maybe gross it up based on today's value. But then that leaves you, Vivek, with a FX risk because you have to monitor that.
Yes, absolutely. And I'm going to ask you for an appropriate cover, a well-drafted currency conversion clause in the counter that will cover me for any fluctuation that I may incur between the day I claim on you and between the day you pay me in that foreign currency. But what is important to address at this point in time on this topic is we have seen several counter commitments with very vague currency conversion clauses, as vague as simply saying the counter issuer shall pay in the euro or the USD equivalent of the claimed amount, period. That's too vague. That's way too risky a cover, in my opinion, because the risk of this kind of fluctuation will eventually be borne by the applicant, as you said, pursuant to the credit agreement. So it's important that you, at the minimum, make a reference to the index of the exchange rate that will be used and the date that will be used for the calculation of claiming the equivalent amount in the said currency. Saying these, putting these vague clauses, in my opinion, it's not going to help anyone. It's more importantly, it's going to put the counter issuer in a very delicate and sensitive situation when claiming back on the applicant, because there you will have to apply the facility agreement, the clause that's applied in the facility agreement. And if you fail to align that clause in your counter, you're going to be ending up discussing with the lawyers of the applicant as to how much they pay you, how much they owe you, or how much not. You all know that. Next to that is quite a basic challenge, I would say, but I think it can be aggravated depending on how wide the technical gap is between the staff of the two banks, or 3 or 4 banks, depending on how many banks are involved in the counter scheme. For instance, Frank, banks in states conveniently choose to stay away from the URDG rules under the excuse of regulation. And I'm not going to blame you for that. But this position of US banks, I think, in my humble opinion, does not serve to the bigger cause of the industry, which is to harmonize the best practices. One cannot harmonize an international practice looking only at one set of rules and completely ignoring the other. But I will be neutral here, and I will accept, even on the European front, I can say that things are not that great. Whenever you come across a request for a beneficiary to receive an undertaking from a local bank, invariably an indirect scheme is proposed, as if confirmation doesn't exist. Confirmation of standby doesn't exist. It's because of their lack or their discomfort or their fear for handling standbys, because they do not have much on the standby locally. It's a fact that standbys are okay. They are a global instrument, but they are relatively less in use in European market than they are in the Americas. So to me, the familiarity of the staff with the governing rules and the international practices, together with the technical system constraints, is definitely something you'll always need to consider when tackling these schemes. Last in the challenge, and I'll be very quick, but this is one of my favorites, Frank, the mailing period. I don't know about you again, but in my humble opinion, 30 days is a bit of a stretch. I don't want to open the Pandora box, but I said it. In my opinion, it's a bit of a stretch to be provided to the local guarantor. I mean, I think it's one of those practices which just got stuck while the entire world has moved on.
I think, Vivek, I think it was brought into it was actually implemented when Slow Boat to China was actually Slow Boat to China, and we didn't have a lot of the electronic means that we have today.
Yep, exactly.
So it's historical, and it gets even compounded when you have multiple counter standbys in the chain. So if you've got 2 counter standbys, now you have to factor in all of that. Add into account the auto extension, and it even extends it even further.
Yeah, sometimes. So it will be just add another one, and your expiry just extends to two more months. That's a direct heavy impact on the applicant because he bears all the commissions. His credit line remains blocked for 2 additional months instead of possibly we could work with, I don't know, a month, by cutting it down to 15 days. To me, anything above 10 days is sufficient, and beyond 15 days is a bit of an exaggeration. But okay, right now it doesn't appear to be an issue, but let's hope that it stays like that, and maybe we'll have to change this. We cannot continue to keep it in the name of market practice. Next slide, please. Now, I don't know how many minutes do we have? 7, I think.
We got about 10 minutes.
Yeah, okay. Let's take a quick look at the way the rules.
Go ahead.
Yeah, I think around about 8.
Yeah.
Let's take a quick look at the way the rules tackle this topic. So first things first, URDG. We know it takes a very detailed approach on this special relationship between the counter guarantor and the local issuer. And I'm not sure if that is a good thing, because sometimes in the world we live in, we know that the motto is less can be more. But unfortunately, URDG, I think they decided to go for the more, and thereby created a confusion as to what exactly is the relationship between the counter guarantor and the local guarantor. And more importantly, it poses a $1 million question, in my opinion. That is, are the obligations of the counter guarantor toward the local guarantor similar to that of a surety? Because if you look at URDG Article 2 and 5, that's fine. You have a very elaborated definition of the counter guarantor, counter guarantee, a demand guarantee, an instructing party. Very interestingly, URDG drafters have defined instructing party as a party who can be other than the applicant. Applicant being a party whose obligations are secured by the guarantee, and the instructing party is the party who is responsible to indemnify the bank. The word indemnify here is used in terms of defining instructing party. But if you look at Articles 29, namely the disclaimer for the acts of instructing party, another party, Article 31, the indemnity for foreign laws, and Article 32, liability for charges. If you look at these three articles in the URDG, which previously talked about the principle of independence between the counter and the local, in these three articles, if you club them together, the kind of cover that the local guarantor is receiving is more of an indemnity that is normally expected from the applicant or the bank client towards the bank, and not from between the counter guarantor and the local guarantor. But URDG does take that approach of providing an indemnity cover to the local guarantor rather than something that is based strictly on the terms of the counter commitment. On the other hand, if you look at next slide, please, ISP, that in my opinion, and you can tell me if you agree, Frank, ISP takes a minimalistic approach when tackling the relationship between the issuer and the person requested to issue separate undertaking. And I think this is most apt. It maintains a single tone throughout the publication that the two commitments remain independent and separate from each other. Especially if you focus on Rule 4, it clearly indicates, cannot be clearer than that. A beneficiary of a separate undertaking, or a counter commitment rather, does not receive any right whatsoever other than the right to draw under the standby period. If you need more rights, more covers, agree on it and put them in the standby.
Yep.
If you do not put them, I'm sorry, but that's what the rules provide for. You didn't ask for it, so I'm going to cover you only what's your issuance fee, basically. If you run into trouble, litigations, foreign laws, imposition of foreign laws, that's not for me as a counter issuer. I'm sorry, and that is where the problems arise. Particularly when we are talking about the American perspective here, mostly we receive commitments subject to ISP 98, wherein we are more familiar with receiving an indemnity kind of cover, which is more close to URDG. And that is where the bankers start playing with the rules and modifying the articles and putting additional covers until they are satisfied with the local issuance or with their local commitment. But that is, of course, not advisable. And it is only advisable under close guidance of experts or people who have a staff who have perfect knowledge of the rules and the implications of modifying it. And unless you have it, I think you're going to end up messing up with it, and there'll be a lot of more other delays, and it's going to cause you more harm than any good. So in my opinion, I'll just close this this part on my side by saying that I think it's always important to pay attention to the rules, practices supporting the instrument. So both standby and the demand guarantee, but more importantly, try and put yourself in the shoes of the local guarantor when requesting the latter for the reissuance. I think it will give you always a holistic view of the transaction, but also your commitment under it. I think that's our time. Frank, I don't know if you made it.
No, Vivek, we made it just in time. Your presentation was absolutely outstanding. It was great to have somebody that has your depth of experience and knowledge of the rules and the process to share with this crowd some of the concerns, and specifically point out some of the rules that we need to take into account when issuing these counter standbys. Greatly appreciate everything that you've done here, and especially since you're on holiday.
Always a pleasure, but it's not a problem at all. I love the topic. So I just made myself available.
I could see that. Well,
and I'm still not done. But okay, Norman is going to come back, and I'm sure he's going to come back. He has come back just to tell us time for you guys to leave.
Absolutely. He's showing us the door.